A little over 1 year ago, the U.S. Supreme Court issued its landmark New York State Rifle and Pistol Association versus Buren ruling, affirming that the Second Amendment protects the right to bear arms as well as to keep them, and requiring lower courts to evaluate gun cases based on what the Second Amendment actually says. In other words, the Supreme Court gave us a 4-ton wrecking ball to use against gun control. And in response, your National Association for Gun Rights went on offense. Almost a year ago exactly, we filed 7 lawsuits against semi-auto bans and standard capacity magazine bans in nearly half of the federal appellate circuits, with the goal of enforcing that Buren ruling and getting a Supreme Court precedent demolishing so-called assault weapons bans for good. Now that we're at the 1-year mark, I wanted to bring y'all an update on where each of those lawsuits stand, as well as a broader look at assault weapons ban lawsuits overall. But first, please take a minute to like this video and subscribe to our channel to stay up to date on all the latest Second Amendment news and updates. Also, make sure to click the link in the description and pinned comment down below to sign a petition opposing all gun control, and we'll keep you in the loop on future action that you can take. So this started right here in our own backyard in Colorado, where we are headquartered. We had national anti-gun groups agitating in the communist area of Boulder County. If you live in Colorado, you know what I'm talking about. And they successfully got a total of 4 local governments to ban semi-automatic weapons and standard capacity magazines. But right after the first local gun ban passed in the city of Superior, the Supreme Court handed down its Buren ruling. And I have to say, y'all, I would love to have been a fly on the wall when those Everytown activists realized what they were in for now. Because they knew, of course, that we were going to be suing, but what they didn't know was how easy the Supreme Court was about to make it for us. We sued Superior exactly 2 weeks later. And 2 weeks after that, an Obama-appointed judge issued a temporary restraining order blocking that gun ban's enforcement. That was the first post-Buren win for gun rights in the nation. After that, we were off to the races. We filed lawsuits against the other 3 local governments here in Colorado. We got a second temporary restraining order from a Biden-appointed judge this time. And then we combined all 4 of those local lawsuits into one and negotiated a voluntary stay of enforcement throughout the duration of the lawsuit. That is the functional equivalent of a preliminary injunction, and it means that those local gun bans cannot be enforced as long as our lawsuits are going. Then, we followed with lawsuits against the 2013 Colorado magazine ban, Mitt Romney's assault weapons ban in Massachusetts, the 2013 Connecticut semi-auto ban, Hawaii's assault pistol and standard capacity magazine ban, and then 2 local semi-auto bans in Illinois. That puts us in the First Circuit, the Second Circuit, the Seventh Circuit, the Ninth Circuit, and the 10th Circuit, which altogether covers half of the country. The ultimate goal here is to get a nationwide precedent from the Supreme Court ending these unconstitutional gun and magazine bans for good. So here's where we're at with each one of those. So first, we have one of our lawsuits out of Illinois. This one started in the city of Naperville, and of all 7 lawsuits, it's the one that's farthest along in the litigation process. Now, just by way of background, back when we were getting ready to file all of these lawsuits together, we found that the city of Naperville had just banned the sale of AR-15s. This was in spite of the protests of over 100 citizens who showed up at their city council meeting to protest that ordinance passing. And they were led by our good friend Robert Beavis. He owns Law Weapons and Supply, a local gun store there in Naperville. Interestingly enough, he's there by Naperville's invitation. Back in the day, years ago, they actually invited him to set up shop there in their city. So he's there by invitation, by their own invitation, when they then passed an ordinance that would essentially put him out of business. So we contacted with Robert, we connected with him, we filed a lawsuit with him as a fellow plaintiff. And then when later that year Illinois passed a statewide semi-auto ban, we just expanded that lawsuit to include the state ban too. The district court ruled against us, so we appealed to the 7th Circuit. We asked them for an injunction pending appeal. In other words, while they're considering the matter, would they please go ahead and just block the gun bans so that Robert doesn't go out of business? The 7th Circuit said no. So we filed an emergency appeal with the Supreme Court asking them to give us emergency relief. Now they did not, but in response to our Supreme Court appeal, the 7th Circuit put us on what our lawyer called the rocket docket. They expedited our oral argument. That took place a couple of months ago. We did a video on how that went. You can find that in the description below as well if you'd like more details on that. So right now, we are waiting on the 7th Circuit's 3-judge panel to rule on the Illinois Naperville gun bans. If they say no, and chances are they probably will, 2 of the 3 judges we drew are not friendly to gun rights, we'll have 2 options. One, we can appeal to the entire 7th Circuit. That's a process known as en banc review. Or we can go ahead and take it straight to the Supreme Court. And there are pros and cons to each approach, so we'll make that call once we have a chance to actually look at the ruling that the 3-judge panel hands down and talk with our lawyer to see what he advises. And then, of course, we will keep you updated. The 7th Circuit includes both Wisconsin and Indiana as well. So if we succeed in getting an appellate level win there, gun rights will be protected in those states as well. If we don't, as I said, we'll just take it to the Supreme Court. While we're in Illinois, our other lawsuit that we filed was against the city of Highland Park's long-standing semi-auto ban. This one's interesting because this actually did go before the Supreme Court before Buren, and they refused to take that case. But once we got the Buren ruling, we figured it was worth another try. So we filed a lawsuit challenging that gun ban's constitutionality. We've been awaiting a ruling at the district court level for quite some time, and chances are that judge is waiting to see how our other Illinois lawsuit goes before he rules, since that one's further along in the process. Next, we have our lawsuit against Connecticut's semi-auto ban. So when Connecticut banned semi-automatic weapons and standard capacity magazines back in 2013, we promised our members we'd come back and challenge it in court, and that's exactly what we did last year. We asked the court for a preliminary injunction to block the law's enforcement during the lawsuit, and the district court said no, in one of the worst, most convoluted rulings I've ever seen. We do have a separate video update on that ruling as well, which you can find on our channel. And just yesterday, as we filmed this on Thursday, I got the notification that our legal team filed our appeal to the 2nd Circuit Court of Appeals. This is the second of our cases to go to the appellate level, and a ruling here will apply to New York and to Vermont as well. That brings us to the Mitt Romney assault weapons ban lawsuit. This lawsuit's a particular favorite at our office, and it challenges the Massachusetts ban on semi-automatic weapons and standard capacity magazines signed into law in Massachusetts by then Governor Mitt Romney, who is currently serving in the U.S. Senate as a Republican, I might add. And by the way, this just goes to show that just because they have an R after their name does not mean they're good on guns. Some of the worst gun control laws we have are courtesy of Republicans, like this one. So we filed our lawsuit to overturn it, and we asked for a preliminary injunction here as well. That ruling could come down any day now, but we're not expecting it to be a pro-gun ruling, since in oral arguments, the judge essentially called a literal interpretation of the Second Amendment a suicide pact. So yeah, we anticipate appealing this one sometime in the next few months to the 1st Circuit Court of Appeals. And rulings there will be binding on Maine, New Hampshire, and Rhode Island, as well as Massachusetts. Now we're going to go to the opposite end of the United States. We have a lawsuit against Hawaii's so-called assault pistols and their ban on standard capacity magazines. As usual, we asked for a preliminary injunction to block the law's enforcement here as well. In this case, though, we recommended that the judge wait on a pair of rulings out of California before he decides. Those rulings will be over California's semi-auto and magazine bans from District Court Judge Roger Benitez, known in the gun community as Saint Benitez for his hard-hitting, solid rulings protecting gun rights. Now, those rulings could come any day now, and it's no exaggeration to say that the entire country is waiting to see what happens in those cases. So I want to take a slight detour here to explain why those 2 cases are so important to the broader assault weapons ban litigation landscape. So the 2 cases are Miller v. Bonta, which goes after the semi-auto ban, and Duncan v. Bonta, which targets the California magazine ban. Now, both of these laws were initially struck down by Judge Benitez. They went to the 9th Circuit, ultimately overturned both pro-gun rulings and upheld the California gun control laws. Then Duncan was appealed to the Supreme Court. And immediately after they handed down their landmark Buren ruling, they took the Duncan case and said to the 9th Circuit, yeah, y'all got this one wrong too. Go read what we said in Buren, try again. What that meant was that now the 9th Circuit had to apply the Buren test, the plain text of the Second Amendment along with its historical context, to the California magazine ban. So the Ninth Circuit punted. They just kicked both cases, the semi-auto ban case and the standard capacity magazine ban case. They kicked both of those cases back down to Judge Benitez, who'd already struck both of those laws once. Now, though, he gets to do it under the Buren test. So needless to say, we're all watching very closely. These are both very high-profile cases, and our judge in Hawaii is watching to see what Judge Benitez says there as well. And as a reminder, the Ninth Circuit includes a lot of other states, including Washington, Oregon, and Nevada, just to name a few. So both those cases and our case out of Hawaii will have a very broad impact. Next, we have our lawsuit against the 2013 Colorado Standard Capacity Magazine ban. So we had actually filed against this one before, but not having Buren at the time, the 10th Circuit upheld the law under their unconstitutional two-step process, which was basically a cost-benefit analysis on the Second Amendment, i.e., if we actually go with what the Second Amendment says here, will we like the results? No. Then let's uphold the gun control and say it's because of public safety. That's what the courts were doing before Buren. But since Buren said they can't do that anymore, our legal foundation filed another lawsuit, and this time we hope to win. In this case, we did not actually ask for a preliminary injunction, so it's going through the process of preparation for a trial on the merits. That means we just finished the discovery process, where the Colorado Attorney General's office got to depose our plaintiffs under oath and request files and documents from us in an attempt to find anything that they could use to tank the case. Now, they did not, because it's a straightforward question of constitutionality. Does a magazine ban violate the Second Amendment? That's a judicial question. That's not a fact-finding mission. So our lawyer plans to move for summary judgment here and hopefully avoid having to have an actual trial, since there's really no need for one. The point of a trial is to establish facts, and none really need to be established here. We know the Colorado legislature banned magazines. We know what the Second Amendment says. The only question here is whether the judge will decide that that law is consistent with the Second Amendment. If not, we'll appeal. But since this one is essentially taking the long way around Robin Hood's barn, so to speak, we're looking at next year before we see a district court ruling. When we get that ruling, if it's against gun rights, we will appeal that to the 10th Circuit, where a win will impact New Mexico, which actually did try to ban semi-autos earlier this year, as well as Utah, Wyoming, Kansas, and Oklahoma. And that brings us back to where we started, the 4 local semi-auto ban ordinances in Colorado that started this whole thing. As I mentioned before, those 4 have been combined into one case, and all 4 have a stay blocking their enforcement during the case. That means the litigation is moving forward on the merits, just like the mag ban case. And we just finished the discovery process here as well. But what I didn't mention is that these 4 local governments are now being literally represented by lawyers from Bloomberg's Everytown for Gun Control. That means that during the depositions, we were literally going toe-to-toe with Bloomberg's hand-picked attorneys, who basically had an unlimited budget to harass our organization and our plaintiffs and to try to poke holes in our case. When our president, Dudley Brown, sat down under oath for his deposition, they grilled him for 4 hours, asking questions that had nothing to do with this case. They wanted to talk about you. They wanted to talk about our members. How many members does an AGR have? What do our financials look like? How many members live in these localities? And they wanted Dudley to give them names. And in Dudley's words, not on your life, pal. We are absolutely not going to divulge private information so those gun grabbers can add them to their registry of targets for retribution. And then this one took the cake. They had the nerve to suggest that Dudley didn't actually know whether our members wanted these gun bans repealed or not. And that is absolute and utter hogwash. And this is the thing. Bloomberg's lawyers know it was hogwash. They were only asking because they had nothing else to go on. That means they know they have no case. And that means, as we knew all along, under the Second Amendment and the Supreme Court's Heller and Bruen precedents, we have every hope of ultimately demolishing these gun bans for good nationwide. And that is the goal. Let's take assault weapons bans to the Supreme Court. Let's get that nationwide precedent, striking down semi-auto bans and mag bans for good. And our Illinois case is actually pretty close to being ready to appeal to the Supreme Court, along with one other case out of the Fourth Circuit, which challenges Maryland's gun ban. Both of those cases are waiting for 3-judge panels to rule, and then they can either go straight to the Supreme Court or be appealed en banc to the 7th and 4th Circuits. And then they go to the Supreme Court. Either way, we're close. And if we have anything to say about it, the semi-auto ban's days are numbered. And if you'd like to help us strike them down for good, we'd ask for your help. There is a link in the description below where you can contribute to our legal war chest to help us continue this fight in the courts. And don't forget to like this video and subscribe to our channel to stay tuned for more updates on these lawsuits.